So first I'm going to bring up Professor Rob Natelson. He is going to introduce the set of draft convention rules that he and Michael Ferris have created. Professor Natelson is a true expert in every sense of the word. He has been cited by the U.S. Supreme Court justices a total of 16 times in 4 separate cases just since 2013. That is incredible. He is widely acknowledged to be the country's leading scholar on the Constitution's amendment procedure. He is the Independence Institute's Senior Fellow in Constitutional Jurisprudence, and he heads the Institute's new Article 5 Information Center. He was a law professor for 25 years, so you really do have a true expert here. Professor Natelson, would you come up, please?
Thank you, Rita. Mark, Representative Ivory. It's common to say that one is humbled to be in such company. I feel humbled, by which I mean I'm somewhat scared. This is a scary group to appear before because the actual experts here are you. I just wanted to, my job is to say a few things about the rules, okay? I'm not going to give you a campaign speech. I'm just going to give you some observations about them. As Rita mentioned, I am the director of an entity called the Article 5 Information Center, which is located in the Independence Institute in Denver, Colorado. I'm not affiliated, and I say this because there have been some misunderstandings. I'm not affiliated with the Convention of States movement. We give advice to all Article 5 movements out there. However, I will say the Convention of States movement has to be commended for, among other things, the fact that it, as much as any other, has helped to lay the groundwork and answer questions pertaining to a proposed Article 5 convention. Last year, for example, it was the Convention of States movement that commissioned from me the writing of a legal treatise, which we refer to as the Article 5 Compendium. This is a guide for legislative drafters, for lawyers working in the area, for legislators working in the area. It's a free guide, and you can get it at the Convention of States website, conventionofstates.com. The drafting of the rules refers to, especially in the footnotes from time to time, this compendium. So if you want more information about why we've done what we've done, very often the compendium provides that information. Now, just by way of background, the rules of the convention are ultimately under control of the convention. No matter what anybody else might tell you, they cannot be dictated in advance by state legislatures or by Congress or by anybody else. Conventions, including conventions of states, historically in America have power over their own rules. This has been specifically confirmed in a case written by former Supreme Court Justice Stevens in 1975. So ultimately, it's the convention, not us, that are going to prescribe the rules. That having been said, it's also true that we can do work in helping to prepare the rules so the convention has something to work with and less to fight over once they actually come together. You know, in the years of America before the Civil War, we held conventions of states on average about every 5 to 6 years. In the years before the Civil War, there were something like 35 different conventions, either among colonies and states. So people were really familiar with what the procedures were, and there weren't a lot of questions out there. Part of what these rules do is they help to anticipate some of the questions that have arisen, because since the Civil War, we've only had one convention of states. That was in 1922, primarily in Santa Fe, New Mexico, and it involved only 7 states. So it's part of the preparation procedure that wouldn't have been necessary early in our history, because early in our history, everybody knew what the rules were. There's another aspect to this too. while you cannot control what the rules are going to be in advance of the convention, what you can do is when you pass an application in your state legislature, you can attach a copy of the rules or reference a copy of the rules and say something like, we want the convention to follow rules something like this. And then, of course, when it comes time to actually appoint your delegates, and they're technically called commissioners, when it comes time to appoint your commissioners, you can instruct them. You can say, we want you to adopt rules like this, we don't want you to adopt a rule like that, and so forth. Okay, the draft rules that we have, that you have in front of you are exactly that. They are a first draft. And they make no pretensions to completion. In fact, there are little aspects, minor aspects of them, typographical errors that have already been changed since the time your draft was done up. They are based on, basically, they're based on the rules of prior conventions. Of those 36 conventions we've had in American history, we have a lot of their rules, so we know what they're like. So sometimes you'll come across funny language here. I mean, the word oftener appears. That's partly because it appeared in earlier drafts, and we're in the process of trying to clean up the language and make it a little bit more modern. You also may notice that these rules are fairly sparse. There are only 24 of them, far fewer than you would have in your legislature. And that also is generally true of conventions. And the reason for that is that every convention uses a source of default rules that apply for most of the circumstances. For example, the Constitutional Convention used the rules of the Confederation of Congress for its default rules. The convention in Nashville, Tennessee in 1850 used the rules that Thomas Jefferson had drafted for the United States Senate. So you need a source of default rules, and after talking to many people about this, we are suggesting Mason's Manual. There are 99 state legislative bodies in the United States. 49 states have 2 chambers, and Nebraska has 1. There are 99 state legislative chambers, and 70 of them use Mason's Manual. Even though these may look a little bit sparse, they're actually slightly more extensive than the rules of any prior convention. And there are basically 2 reasons for this. Number one, there are some things that to our forefounders would have been obvious and don't have to be in the rules, everybody would understand it. But because we haven't had a convention in so long, far fewer people understand it, and a lot of things are not obvious. For example, it would have been obvious in our history at any of the prior conventions of states that if the convention is about term limits, you can't stand up and start make motions about balanced budget, okay? You have to stay within the agenda of the convention, and if you go outside the agenda, the motion is out of order. Well, that is not obvious to some people today, and so a rule is included which says that a proposed motion that's outside the agenda of the convention is out of order. In addition, we had to make a few changes to accommodate changes in conditions and technology. You'll see references in these rules to handheld portable devices, right? You will not find those in the rules of the Constitutional Convention or of the Continental Congress. They had to be added. In addition, prior conventions have generally been secret, with the delegates held under obligations of honor not to reveal what was going on. Our advisors were unanimous that that would not fly today. And so the rules assume an open convention except in a very few minor details. And then there's another obvious one. All of the attendees at all of the prior 36 conventions were male. Thank God that's going to change. And so you see the reference to he and she. Okay, so those are some ways in which these are a little bit different from prior rules. Now, what we hope you'll do is go to the Convention of States website and offer your frank comments on various issues regarding the rules. There are some aspects of these rules which are pretty subjective. They're sort of a stab in the dark. Let me give you one example. None of the prior conventions limited how long a commissioner could talk. You know, Alexander Hamilton, the Constitutional Convention, spoke essentially all day one day. At the convention in Washington, D.C. in 1861, they argued for a whole day as to whether they were going to impose a time limit on speakers, and they decided not to do so. But in today's condition, where we have 50 states and you're likely to have more commissioners, most people recommended that we do have a time limit. But we'd like your feedback on that. For how long a time limit should be, we heard recommendations anywhere from 3 minutes to 30 minutes. We put in 10 minutes, but that's a stab in the dark. So again, we'd like your feedback. Those are the kinds of things that are really important to respond to. Also be sensitive to the fact that some of the rules are more fundamental than others. And I want to close with this, one in particular, and that is the one state, one vote rule. You can make an argument that one state, one vote is not very important. And just in case I'm ever quoted out of context, I want to say I don't agree with this argument. You can make the argument that one state, one vote is not that important. David Goldenshoe, you here, Dave? He's an Article 5 expert from Rome, Georgia, has actually run the numbers and has found that even if the convention voted according to population, in current conditions it would have about the same political composition as if it were a one state, one vote. And you can also make the argument that, gee, this is only a proposal convention, this is not a deciding convention, so who cares? I think there are very, very compelling reasons, overwhelmingly compelling reasons, for keeping the one state, one vote rule and not diverging from them. This can be, in fact, a very big deal. The first one is constitutional and theoretical. The Convention of States is a meeting of sovereignties. The Convention of States model originally is international law. In international law, meetings of sovereignties, the sovereignties are essentially equal. It is one state, one vote. Every prior convention for which we could find a voting rule, extending from the 1670s all the way until 1922, was one state or one colony, one vote. In addition to that, many of you familiar with the Federalist Papers know that James Madison made the point that the government that was created is partly national and partly federal. And he specifically cited the amendment process as one that's partly federal and partly national. We already have a national system for proposing amendments. It's called Congress. Congress has the power to propose amendments. That's the national body. This is the federal method of proposing amendments. This was designed to be a method by which the states, under conditions of sovereign equality, could propose amendments. So if you start moving to something that looks more like Congress, you're undercutting the constitutional design. But in addition to that, there are some very practical issues here. Many of the activists, in fact, I would argue almost all the activists, who have helped get the process this far along and who need to be counted on for support to bringing it to completion, they have been promised, and it has been represented to them, that this will be a one state, one vote convention. You change that and they will feel betrayed, and that is the end of the movement. There is also the practical aspect that the effort to change something from one state, one vote to another voting rule, this has already been tried, and every time it's been tried, it's failed. I could cite you several examples, but let me give you one. Nashville Convention, 1850. The great Commonwealth of Virginia was the most populous state of the convention. The Commonwealth of Virginia stands up and says, you know, we don't like this one state, one vote rule. Let's move to something more like population. So they moved to amend the rules to move from one state, one vote to something more like population. Whereupon the great state of Alabama stands up and says, well, we don't like one state, one vote either, but we don't like the Virginia plan, so we move that we amend the amendment, okay? This discussion went on for an entire day while they argued about whether there ought to be an alternative rule and what that alternative rule would be, and what do you think happened? At the end, they went back to one state, one vote. Because ultimately, that is the only formula in a convention of states that is going to have legitimacy. And the same thing applies to proposed supermajority rules. At the Santa Fe Convention in 1922, there were only 7 states present, so what they did is they tried to work on a rule of unanimity. After a while, they said it didn't work, they gave up, they went back to majority votes. So as a practical matter, that's one rule I would strongly recommend that you not play with, that there's a risk that you could torpedo the movement and sabotage the convention. At any rate, we look forward very much to hearing your reactions to the rules either today or in the future. Thank you.